I would note that on July 26th, Mr. Bellisario sent a series of texts, and part of my language I will quote, "I'm going to murder you, slut. I'm going to kill you before the 30th, slut bag. See you in the afterlife, slut. See you soon, whore bag." Basically showing...
State of Nevada versus Bradley Bellisario.
Good morning. Appearances, please. Actually, we're almost there.
Melanie Marland, bar number 14577 for the state of Nevada.
Ross Goodman, bar number 7722, on behalf of Mr. Bellisario, who's appearing via Bluetooth.
All right. Good morning. Let's see here. So this is our state's motion to remand defendant without bail due to new charges. You want to go ahead and make your motion? Any oral argument?
Briefly, Your Honor, I would just note that NRS 178.487 is directly on point. Every release on bail is predicated upon defendant's good behavior while out, especially on a felony case. In the instant case, the defendant not only picked up a new felony for the exact same charge, albeit against a different victim. New aggravated stalking. The new victim on that case is an individual whom the defendant believed was having an affair with the defendant's new girlfriend, Ms. Bakhta. The defendant went ahead and sent dozens of text messages to this individual, Mr. Ellerman. Those text messages ran the lines of threatening Mr. Ellerman with a Colombian bow tie. If Your Honor is not familiar with that term, that's basically when someone's throat is slit and their tongue is pulled out of the throat. Mr. Bellisario is an attorney. So Mr. Bellisario's position was, hey, you know, my clients are going to come over. I have drug cartel clients. They're going to come over, give you Colombian bow ties, have fun with that. Mr. Bellisario furthermore called Mr. Ellerman, tried to have him come by for a fight, harassed him in the sense that he went to Mr. Ellerman's work intranet website and started commenting on every single one of the reviews of that brokerage business, basically accusing Mr. Ellerman of ethical misconduct and criminal behavior. Most concerning to the state are obviously the physical threats made to Mr. Ellerman. I would also note that the instant underlying facts are extremely concerning. In our case, Mr. Bellisario had separated from his wife, Emily, in early 2019. He is currently charged with a course of conduct between January and July of 2020, wherein Mr. Bellisario sent multiple threatening text messages and made multiple calls to Emily. On June 11th through June 22nd, he sent a series of messages to Mrs. Bellisario. He also, on June 22nd, while she was out with her children, came by, started ramming his car into her garage, started breaking the neighbor's cars. He was looking for her. He tried to break down the door. Ultimately, she fled to her father's house and got a TPO 2 weeks later on July 6th. The extension for that TPO was scheduled for July 30th of 2020. I would note that on July 26th, Mr. Bellisario sent a series of texts, and part of my language I will quote, "I'm going to murder you, slut. I'm going to kill you before the 30th, slut bag. See you in the afterlife, slut. See you soon, whore bag." Basically showing the violent threats made to Mrs. Bellisario, and she is absolutely terrified. Granted, Mr. Bellisario was granted $10,000 bail upon the indictment return with mid-level electronic monitoring. His trial in this case was scheduled for August 2nd. There was a defense continuance of that trial date, no objection by the state. And then on July 30th, Mr. Bellisario, the defendant in this case, sent directly an email to the prior prosecutor, threatening her with a lost civil suit, which, that's fine, we send that over to civil, but then the end of that email was, "Take care of your little one." And that prior prosecutor has a young son, obviously, was extremely concerned. She is now off the case, so Mr. Bellisario achieved his goals, and then when civil told Mr. Bellisario to cease and desist with that behavior and contact with the prior prosecutor, Mr. Bellisario then started sending dozens of emails again to civil counsel. Also harassing, also insulting emails. Now, given the fact that over the course of the last, well, between August and September, early October of this year, Mr. Bellisario has picked up 2 new cases against 2 different victims. Similar type of behavior, basically wherever he feels slighted, Mr. Bellisario reacts and threatens people. The state is requesting that pursuant to NRS 178487, Your Honor, remand him without bail and revoke his bail. He got his bail, he had the opportunity of staying on good behavior, and instead of doing so, Mr. Bellisario went ahead and kept terrorizing members of our community. Not only do we have the underlying case where he's threatening an intimate partner, but now he's threatening members of the legal community who are prosecuting him, as well as any person he believes has interfered with his right to have a relationship with anyone, whether it had been Mrs. Bellisario at the time or this individual who he believed had a relationship with his new girlfriend. So based on all that, the state is requesting remand without bail. We are asking to be revoked for $10,000 with mid-level. I would note that in his new case in Department 7, Judge Karen Bennett Herron is holding him without bail pending preliminary hearing in December. His house arrest was also revoked in the remaining TPO case that's still in JC1. So based on all that, based on the facts of the new cases, based on the facts of the underlying case and the violation of his release conditions, we're requesting a no bail hold at this time, pursuant to statute.
Thank you. Understood. Response?
Thank you, Your Honor. There was a lot of argument there, and not much for this court to revoke Mr. Bellisario on. If you look at NRS 1784.487, it clearly says that the court may revoke based on the circumstances of the actual charges. So there's no revocation because he picked up a new felony. Let's put everything in context. This court, not Your Honor, but the judge that preceded you, had the $10,000 bail and house arrest for the case that the state just got done describing, involved an ex-wife, a very volatile, contested, a prolonged divorce and custody hearing. There's a lot of things going back and forth on both sides. It doesn't excuse Mr. Bellisario's use of profanity and abusive language, but he was reacting to very egregious circumstances that took place in the custody case. That was ongoing. There was $10,000 bail and house arrest. He is put on scram, and during that period of time, Your Honor, nothing happened. For 8 months that he was on scram, guess what? He complied. There was no issue. He gets off scram, and then he gets picked up on a false violation of an extended protective order. Again, not justifying any email that Mr. Bellisario sent to the state prosecutor, but he held the state prosecutor responsible for causing him to be arrested on a protective order that didn't exist, causing him to be detained for 3 weeks, causing him to miss the hearing in family court where the family court judge then where he lost custody because he allegedly or reportedly in that case was picked up on a new case, which ultimately was dismissed because extended protective order was not served on Mr. Bellisario. So that's what fueled Mr. Bellisario to send that email as a lawyer to the state prosecutor. Now, he shouldn't have added at the end those 4 or 5 words. I'm not sure that rises to the level of a threat. It's open for interpretation, but that's not the issue before this court. Before this court, there's one case, Your Honor, and that's the case involving Mr. Eller. And it's true. There are text messages allegedly from Mr. Bellisario where he's talking all nonsense, crazy things that somebody of sound mind and that's not drunk would never send to anybody. Mr. Eller did know of Mr. Bellisario as a personal injury lawyer, not anybody that's ever represented or practiced in the criminal defense arena. And during one of these drunken stupors, he gets upset, and like the state says, he reacts. Is that the right way to react, by sending things that are obviously absurd on his face. But you don't come in and you ask for him to be remanded and to have his house arrest revoked because he's sending text messages. Because that's all there is, Your Honor. It would be different if the state were coming in here, and I might argue something differently, if there was any affirmative action on behalf of Mr. Bellisario to indicate that there was anything other than somebody standing behind a keyboard being a telephone tough guy and being upset about the fact that he thought that this individual was dating his girlfriend. Doesn't make it right. He's facing new charges, but there was no affirmative action. There was no words outside of those texts, nothing else, and no action to follow up on those text messages. So now you have somebody standing before Your Honor who has suffered permanent collateral consequences. He's been suspended. His law license has been suspended. He's not practicing law anymore. His children have been taken away from him. He can't be in their lives anymore. He's still fighting, defending the first case against his ex-wife, and now he has this new case. And the difference, Your Honor, as whether or not you reinstate him, because as this court knows, the trial in this case is not until June of 2022. That's a long time to stay detained on a new allegation of text messages, and that's all there was to Mr. Ellerman. And the obvious difference to have a change of conduct for Mr. Bellisario, so this court knows that something different is put in place, so he doesn't react to somebody, is that you put him back on scram. Because we know, we have proof, Your Honor, the course of conduct was for 8 months, Mr. Bellisario has no issues, he doesn't react, he's not sending text messages, and he comes off scram, and now we have these two cases that the state just told you about. Again, that if there was something more to indicate that Mr. Bellisario was doing something other than just sending out these text messages, it may be a different situation, but we don't. And I would ask this court to reinstate him with the added condition of scram.
May I briefly reply?
Mm-hmm.
Thank you. A few things. First of all, the drunken stupor apparently lasted for over 2 weeks because these text messages, phone calls, Facebook messages, Instagram messages to Mr. Ellerman as well as his business and the woman in question, Ms. Bacta, took place between September 27th of 2021 and October 13th of 2021 at all hours of the day. In fact, there's a sequence of texts from Ms. Bacta to Mr. Bellisario, and I did not attach those, but basically stating, it's 11 a.m. I thought you had just had a drinking problem, but it's 11 a.m. So I don't know if he was in a drunken stupor for 2 weeks, but that doesn't excuse behavior. In fact, someone being drunk doesn't even excuse murder. It can be an affirmative defense, but it doesn't excuse someone committing a crime, as Your Honor well knows. In terms of the false violation of TPO, the defendant was in custody, true, for a few weeks. That was in January of 2021. And the reason his trial is continued to June of 2022 is at the defense's request. It was a defense request for continuance. We had no objection to it, but that trial got moved to June 2022. Less than 3 days after that motion to continue, Mr. Bellisario sent that email to the prior prosecutor and all those other emails to the civil attorney. He wasn't arrested on that case. And then 6 weeks later, this course of conduct on this new case where the defendant is threatening Mr. Ellerman. Phone calls as well, basically threatening to come over, threatening to kill him, saying come over. He called Mr. Ellerman over and over again. Those are courses of conduct, Your Honor. That is a new felony charge for aggravated stalking. So again, in terms of the collateral consequences, Mr. Bellisario only has himself to blame. That is not Mrs. Bellisario's fault. That is not Mr. Ellerman's fault. That is not the prior prosecutor's fault. Mr. Bellisario needs to take ownership for his own actions, and he picked up 2 new cases, not anyone else. So the fact that his trial is moved out all the way to June 2022, that is on Mr. Bellisario. Based on that, the state is still requesting remand and revocation, the scram. While it's wonderful that it worked for 8 months, obviously, Mr. Bellisario didn't learn a thing. And the state's concern at this point is the physical conduct that was done with Mrs. Bellisario shows that he is very well capable of showing up at people's places and causing damage. So again, I'm requesting remand and I'm asking revocation of it.
Okay, so in this case, we have aggravated stalking and malicious destruction of property. What and on CR 047550 is also elevated or aggravated stalking.
That's correct. That's the aggravated stalking against Mr. Ellerman. Aggravated stalking charges are 2 to 15 years in terms of the range of sentence.
And then 48116 is, what are the charges in that one?
48116 are the currently threatening and obscene letters that were sent to the prior prosecutor.
Okay, and what's the charge?
It's a misdemeanor sending threatening
Okay, gotcha.
communication.
All right. Was the scram bracelet removed at some point?
It was, Your Honor, because it was ordered by the family court judge, and so the family court judge then removed it. It was never ordered by criminal courts. And, obviously, when the state says respectfully that Mr. Bellisario didn't learn anything, I mean, she just said it worked for 8 months. It did work for 8 months. It's off. And then he does have a drinking issue. He does have an alcohol issue. And all the stuff that the state wants to hold Mr. Bellisario accountable for, that day will come. That's not the issue. The issue is whether or not he should be reinstated with the added condition of scram based on this new case that essentially, Your Honor, are text messages to Mr. Ellerman. That's all. There could be an order not to have any contact with Mr. Ellerman, which already exists. There's temporary restraining order. He can be on scram, and then we can have our day in court. But it doesn't escalate to the level of remand until his trial, especially when we know there's an alcohol issue that induced these rants, and that there's no follow-up, there's no affirmative action, there's no other words, just somebody behind a keyboard who's pissed off, who's sending text messages. That's the charge, and he'll be held accountable at that point. But as far as pre-trial release, Your Honor, with the added condition of scram, the court should feel comfortable that this isn't going to happen again.
And if I may, just one last thing. The only proof we have that Mr. Bellisario actually has a real drinking problem is the defendant's own statements at this time. There's no proof of such a thing. Now, I understand that scram, again, may have kept Mr. Bellisario from sending texts or showing up at the victim's house. He had a bracelet on when he committed all these new crimes, and he was out on bail. At this point, again, the state believes the remand is appropriate.
And Your Honor, I just have to respond for the record. That's the point of having a revocation hearing based on allegations like that. That there are text messages replete by both his first wife and now this girlfriend's boyfriend saying you have a drinking problem. It's replete. It's all over in family court, which is why you got this scram. And the whole misdemeanor malicious destruction of private property, he got arrested on the DUI. That's what that was about. So the DUI went away, the malicious destruction of private property went with the new case. That's what was going on there. Obviously an alcohol issue, which can be monitored with scram.
All right. Well, the major things of all of the factors I'm to review that I'm concerned with, of course, is the apparent, the risk to the community. That's what I'm concerned with. It's the, nature and seriousness of the danger to the alleged victim and any other person in the community. It seems to be expanding his circle of who he's threatening and who he's angry at. And also, number 9, the likelihood of more criminal activity after he's released. Those are things that the court's concerned with. The newspapers are always full of these cases where the person gets out and then the devastating happens, even though they think it's just threats. So here's my thoughts. On the other hand, he went 8 months without a problem. It does seem to be tied to drinking. So the court accepts that. I'm thinking of house arrest with high-level monitoring and a scram.
May I just inquire as to when the defendant was on scram? I don't have that information since it was a family court issue.
Mr. Bellisario, if you remember offhand, I don't have those notes in this file.
I think it started in October and then went for about 8 months.
October of 2019?
What year, Brad?
2020.
And for the record, house arrest does not alleviate the state's concern given the fact that being on monitoring obviously hasn't stopped the defendant from acting in the manner in which he did.
Right. Further, the order is going to be, I don't know if there is, I almost want to take his phone away. You know, it's like to help you from yourself. No contact, no written, no verbal, no phone calls, no text messages, no Instagram, no nothing with any of the victims. And I'm going to expand it to anyone close to them. Mr. Bellisario, you have to stop communicating in a negative way with everyone, especially people that are afraid of you. Can you do that?
Yep.
Okay. All right. That's going to be my order. House arrest, scram, high-level monitoring, no contact.
Are you reinstating the bail, Your Honor, or just?
And reinstating the bail.
So 10,000?
Yes.
May I ask for an increase in bail? Give them some incentive to follow the court order? Because no contact on one victim obviously isn't stopping him from.
Right.
Well, he's indigent at this point, Your Honor. He no longer has a law license. He has enough issues going on. I'd ask the court. I mean, with the scram, I think that would satisfy this court.
The court believes that an increase in bail is not going to affect this defendant's likelihood of reoffending. It's what's going to make him not reoffend is staying sober, is what it sounds like, and having accountability for his whereabouts, who he's talking to, and what he's saying, and that's what we have. So if there's a violation of any of these orders, of these conditions of your release, then it will be revoked and you will have to stay in custody, because I don't feel the community is safe from you if you're going to continue to make decisions that lead you to threaten people, okay? So the only way you're staying out of custody is if you do not threaten people anymore and you do not do anything that would hurt someone else's person or property, okay?
Yep.
Did Your Honor order no internet usage, or was that just a recommendation?
Defense,
House arrest could.
is it emails it's commonly the problem?
Well, it was text messages, Your Honor, but I think if there's an order of no contact with the two alleged victims in this case.
Three.
Mr. Ellis, I believe was his
Well,
name.
Mr.
Well, Mr.
Ellerman,
Ellerman.
the prior prosecutor on this case as well.
Yeah, so at a minimum, Mr. Ellerman, the prior prosecutor on this case, and the
And
defendant or the victim in the original case, as well as any of their close family or friends that you could contact through them. You cannot contact any of them at all for any reason. Any reason. If you need to contact the victim in this case with regard to the children or something, it's going to have to go through attorneys or through the court or something. But
Yeah, I haven't spoken to her.
Contact for now. All right.
Yeah, I haven't spoken to her in like a year and a half, so it's okay.
Pardon?
Well, I said I haven't spoken to her in like a year and a half, so.
All right. Well, I'm sure it's everyone's hope that gets better, but it's going to have to start with you. That'll be the order.
Thank you, Your Honor.
Thank you.
Sorry,